The morning an HOA president showed up with a cop and threatened to bulldoze my orchard, I almost thanked her. Not because I'd lost my mind, but because when a person that arrogant finally steps all the way over the line, they stop hiding where they're weak. And standing there in the cold September light, with dirt on my hands and coffee still warm in the mug, I realized Geet Whitmore was about to make the worst mistake of her life. It was one of those clear Blue Ridge mornings that makes everything look honest. The apple trees were glowing gold. The pear leaves were just starting to turn, and I was bent over a busted irrigation line, trying to decide whether it needed a patch or a full replacement, when I heard gravel crunch. I looked up and saw a sheriff's cruiser first, then a pearl-white Escalade with an HOA placard in the windshield, like it was some kind of diplomatic credential. Out climbed Geet Whitmore, arms crossed, jaw tight, walking toward me with that stiff little march people get when they think authority is a personality. She didn't say good morning, didn't ask a question, just jabbed a finger at my orchard and said, "This eyesore breaks every rule. Shut it down today, or we'll bulldoze it. Officer, handle this." The deputy looked about 26 and already tired of life. He shifted his weight, glanced at me, then at her, like he knew he'd been dragged into something stupid. I wiped my hands on my jeans, took a sip of coffee, and said, "Geet, before you bulldoze my family's land, you may want to check the deed on your clubhouse, the one built on my property rights." You ever see the exact second a face loses color? Hers did, just drained out. The deputy's eyebrows jumped, and for a moment nobody said a word except the pump ticking in the background and a few leaves rattling in the breeze. She opened her mouth, shut it, opened it again, and started sputtering about legal action, trespass, county enforcement, all that noise people make when they have no idea how badly they miscalculated. But to understand why that moment mattered, you need the full story, because none of it makes sense without the years that came before it. My name's Reuben Calloway. I'm 51, retired from land surveying after 28 years, and I own 17 acres in Harrow County, Virginia, land my grandfather bought back in 1958 for a price that wouldn't buy a used riding mower now. He planted fruit trees because he believed growing food gave a man backbone. My father kept the orchard alive through droughts, bad markets, bad luck, and plain old exhaustion. When he died in 2019, the land came to me free and clear. No mortgage, no liens, no loose ends. I've got the deed, the survey plat, and the tax records framed in my kitchen. And I know that sounds a little strange, but I've spent enough of my life reading land records to know paper matters. A surveyor learns to respect boundaries because the world gets expensive when people ignore them. For years, things were peaceful enough. Then the subdivision next to me got built Sycamore Bluff Estates. Big houses, polished signs, ornamental grasses, people paid money to install, on purpose, the whole thing. Their first HOA president was a reasonable man. We shook hands, understood each other, moved on. Then he moved to Florida, and Geet Whitmore took over because nobody else wanted the job, and she wanted it way too much. She was the kind of woman who treated bylaws like holy scripture and herself like the only living prophet. She sent violation notices over weeds that weren't weeds, mailbox posts leaning a hair too far, wind chimes being too audible, patio cushions being the wrong shade of blue. That sort of person. Still, my orchard wasn't in her HOA, not 1 inch of it. So I figured her power ended where her property map ended. That was my mistake. She started building a case against me piece by piece. First, it was little complaints the irrigation pump was too loud. The compost smelled bad. My deer fence was too tall. My hand-painted farm stand sign was ugly. My runoff might maybe possibly affect common areas. Every time the county came out, they found nothing. Every single complaint died right there in the dirt. But Geet wasn't trying to win each complaint. She was building volume, a paper trail, a fake pattern. I learned that from my neighbor Wendell Oakes, a retired attorney who lived inside Sycamore Bluff and hated HOA theatrics even more than I did. He came over one evening smelling like bourbon and pipe tobacco, handed me a folder and said, "She's talking to a real estate attorney. She wants a private nuisance case. That made me laugh, but not because it was funny, more because it was desperate. My orchard had been there since 1958. Their subdivision showed up in 2015 in Virginia. If a FAR was their first, the law gives it real protection. You don't move next to a working orchard, then act stunned when apples, compost, tractors, and customers exist. Still, a bad case can cost real money even when it loses. That's the dirty little truth. Sometimes the point isn't to beat you in court. Sometimes the point is to make defending yourself so tiring, so expensive, so aggravating that you quit. So I got organized. I asked the county planning office to put in writing that my orchard was grandfathered and compliant. They did. I made copies. One for the safe, one for my attorney, one for the barn. Then I did something Geet probably hated more than any legal document. I talked to the local paper. Not about her, not directly. I just told the story of the orchard, my grandfather, my father, old photos, the first apple trees. The paper ran a Sunday feature on the place, and folks around town shared it all over. Sycamore Bluff residents started calling me, emailing me, telling me they were rooting for me. That's when Geet escalated, because public embarrassment does strange things to proud people. She hired an attorney in Charlottesville who sent me a letter claiming my weekend farm stand was a nuisance, and this still makes me smile, violated Sycamore Bluff's HOA covenants. Their covenants. On my land. It was like somebody trying to ticket a deer for parking in the wrong church lot. My lawyer, Marcus Delgado, answered with one of those letters that stays polite while still drawing blood. He cited the farm protections, cited the county letter, cited the plain fact that the HOA had no jurisdiction over my property, and warned that continued legal harassment might create liability for them instead. And that should have ended it. But people like Geet don't stop when they're wrong. They stop when something hurts. So while she kept filing complaints and dragging agencies into it, I started digging through the land records the way some people work crossword puzzles. Old plats, deeds, title abstracts, easements, every dry little line of text that most folks never read. One rainy Wednesday night, I found something that made me sit up so fast I nearly knocked over the lamp. The Sycamore Bluff Clubhouse parcel, the one with the pool, parking lot, meeting room, all of it carried a permanent access easement tied to my family's land. My grandfather had negotiated it decades earlier when the county rerouted a road. That easement ran with the land. It never expired. It wasn't subject to the HOA's rules. It belonged to property itself, and that meant it belonged to me. Now that alone was enough to ruin Geet's little fantasy, that she could order me around from the edge of her lot. But there was more. Buried in the title history on that same parcel was an old recorded lien never cleared, never discharged, just left sitting there like a lit cigarette in dry grass. A business debt from before the subdivision ever existed. The developer had somehow transferred the common area parcel to the HOA without cleaning it up. The title company had missed it too, and after enough bank mergers and enough years of neglect, that debt was still alive with interest. Marcus helped me track down the current holder of that obligation. I bought the lien, not the property. I didn't secretly become king of their swimming pool. What I bought was the legal right to enforce the debt tied to that clubhouse parcel. And the second that paper hit my hands, the whole balance of power changed. I kept quiet for a while. Let her keep pushing. Let her file a health complaint about compost. Let her stir up 2 homeowners to sign affidavits over Saturday traffic. Let her file for an injunction against my farm stand. I'd had enough of being patient. When her lawsuit landed, Marcus filed our response, hit back with an abuse of process claim, and tucked one little paragraph near the end mentioning that I now hold a recorded lien interest in certain HOA property. That got their attention. The settlement conference happened in Marcus's office. Geet wasn't allowed in, which bothered her enough that she called me herself to argue about it. That alone told me she was rattled. Her attorney came alone, and try the usual dance. Maybe I'd limit my farm stand hours. Maybe I'd build a privacy fence. Maybe we'd all just quietly walk away. Marcus told him no. Then he laid out the terms. They drop everything permanently. They acknowledge in writing they have no authority over my land. They reimburse my legal fees. And the lien issue gets resolved too. That was the moment, I think, when the room changed. Because once Geet's attorney explained the HOA members what a recorded lien on common property actually meant, and once they learned she'd spent 2 years burning dues money on a personal war, she couldn't when homeowners started turning on her fast. And here's the twist that really mattered. It wasn't me who finished her. It was her own community. Wendell and a group of residents gathered signatures and forced a special meeting under state HOA law. Enough people in Sycamore Bluff were angry now that the thing had its own momentum. By the time that Saturday meeting rolled around, the clubhouse parking lot was packed full. Cars spilling down the road, folks standing along the walls inside. The room smelled like industrial carpet cleaner and bad coffee. Folding chairs, raised voices, tight faces. Patricia from the local paper sat in the second row with her notebook open like she knew she was about to get a front-page story. An accountant homeowner stood up first and walked everyone through the numbers. $38,400 in HOA legal fees over 2 years. Reserve funds drained. Repairs delayed. Dues effectively wasted on a grudge match with a neighbor growing apples. Then Marcus explained the settlement in plain English. The title insurance company would cover the lien issue, not the homeowners. My fees would be repaid. A recorded covenant would permanently confirm what should have been obvious from the start. Their HOA had no say over my orchard. The vote passed 41-6. Then came the vote asking for Geet's resignation. She stood up and gave one of those speeches people give when they confuse stubbornness with principle. Talked about community standards, property values, vigilance, said she acted in good faith and would do it again. And when she sat down, this retired firefighter a few rows back just said, calm as Sunday morning, "Ma'am, you spent my money attacking a man's apple trees." I think that tells us everything. That broke the room open. The vote against her was overwhelming. Not legally binding, but final in every way that mattered. I got permission to speak after that. I walked to the front with a manila envelope under my arm and looked out at all those people, most of them decent. Most of them caught in something ugly they hadn't started. I told them I wasn't there to take their clubhouse. I wasn't there to punish families for one woman's obsession. The lien had been leveraged, nothing more. And once the settlement closed, the title would be cleaned up and their property would be theirs, clear and simple. Then I handed out a 6-page timeline. Every complaint, every filing, every dismissal, every dollar burned. Not as revenge, as record. Because memory gets soft and paper doesn't. I told them my grandfather planted his first apple trees there in 1958 because he believed growing food was a form of dignity, a way of saying, quietly, I belong here. I said, I hope the community would let that dignity stand. When I went back to my seat, the room started clapping. Not polite little HOA clapping either. Real clapping. The kind you feel in your ribs. Geet resigned 11 days later. The insurance payout cleared. I recovered my legal fees and made a fair return on the lien purchase. I used some of that money to start a small agricultural scholarship in my grandfather's name. I gave a strip of land along my north fence a conservation easement, so it can't be swallowed by development later. The orchard had its best season on record. Families came out for cider and apples. Even some Sycamore Bluff residents started showing up, smiling a little sheepishly, buying fruit, bringing their grandkids. And that, to me, was the sweetest part. Not the money, not even Geet leaving. It was walking back across that clubhouse parking lot after the meeting, across ground my grandfather had protected before I was born, and realizing land remembers longer than ego does. Rules change, boards change, loud people come and go, but truth when it's written down and rooted deep enough, has a way of waiting them out. What I learned from all this is simple, and a little bitter too. Petty power survives on other people not knowing their rights. That's the whole trick. The minute you read the deed, read the plat, read the law, and understand what's actually yours, that trick starts to die. So tell me this: when somebody abuses a little power for long enough, and the only way to stop them is to hit back with the law just as hard, is that justice or is that revenge with better paperwork? And have you ever had to stand your ground against somebody who thought rules were only for other people? Share your story. Because I promise you, more folks have lived through that kind of fight than most people realize.